Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. Folks, we are dealing with an extremely biased Supreme Court. And that bias is for Donald Trump. In fact, he put 3 folks on the court. And so since he's been back in office, he has gotten nearly everything that he has asked SCOTUS for. That is a real problem, especially for African-American people, because that's where their hostility is centered toward African-American people, civil rights policies, voting rights, fair housing rights, etc. They may disagree on other things, but they're all in agreement about rolling back very precious, very needful and necessary civil rights on all types of levels. So again, we're dealing with an extremely biased Supreme Court for Donald Trump. And so, therefore, the Democrats have got to fix this. They're the opposition party. They got to fix it. And what we got to do is we got to get them in a position to fix it. I'll talk about that at the end of this video. But yes, these 6 people dominate the court. And really, you could say dominate the country. Because nearly everything is coming through them. And once again, in the overwhelming majority of the cases, they're siding with Trump. All right, now, most recently, they agreed to hear Trump's challenge to birthright citizenship, an extremely important case. Now, recently, they heard something somewhat related to birthright citizenship, and that was whether or not lower court judges could issue nationwide injunctions. Well, now they're going to hear the case that the whole thing is about in the first place, and that is whether or not Trump's executive order can, in fact, change birthright citizenship. So he basically wants to make it illegal or unconstitutional for a child who is born of parents who are in the country legally to become a citizen. Since 1898, the United States Supreme Court has said that children born of parents who are not diplomats or who are not aliens of a foreign hostile country, children born to those parents are citizens pursuant to the citizenship clause, which basically says if you're born in this country and subject to the jurisdiction thereof, then you are a citizen. Well, Trump is trying to change that. And again, SCOTUS has only heard the nationwide injunction part of this case, but they've decided to hear the actual merits of the case. And there are 6, as we just saw, very far-right conservative justices on this court who will give him exactly what he wants if they, a lot of them, if they've been especially moved by the arguments that Trump has made. All right. If they are not moved by that, and if they stick with precedent, and I mean, it is precedent that goes back, this case that I'm referring to, this case goes back to 1898. And within that case, they cite precedent that goes all the way back to English common law 300-400 years ago. So this would be a major, major, major upturning of precedent if they go along with Trump. And it's at least probable, just based on their record. Now, they may say no. They may say, no, that's a bridge too far. I don't know. We'll see. But just the fact that they granted the writ of certiorari that the Trump administration filed itself is telling. They only needed 4 of the justices to agree to hear the case, but it will take at least 5 of them to give Trump what he wants. All right. Not only the birthright citizenship case, but they also gave Texas and Trump what they wanted by allowing Texas to use the new voting map that the Texas legislature drew up a couple of months ago. It was challenged. A 3-judge panel heard the challenge and said it was racial gerrymandering. The Trump administration asked SCOTUS for assistance, and SCOTUS gave it to them. So again, we see how biased SCOTUS is for Trump's agenda. And we cannot go on like this because this court is so much biased toward Trump. Anything he asks for over the next 3 years, he's subject to get. And my concern, my major concern as an African American are their attack on civil rights. In fact, Chief Justice John Roberts and several of the others have been hostile toward voting rights nearly for all of their professional careers. So I'm very concerned. And that's why I say the Democrats must fix this, but they're not able to fix it unless we put them in a position to fix this. So the case that allows Texas to use the voting map, I want to read a portion of it. It says, with an eye on the upcoming 2026 midterm elections, several states have in recent months redrawn their congressional districts in ways that are predicted to favor the state's dominant political party. So they're starting out basically saying this was not racial gerrymandering. This is political gerrymandering, which they have deemed appropriate under the Constitution. Texas adopted the first new map. Then California responded with its own map for the stated purpose of counteracting what Texas had done. North Carolina followed suit, and other states are also considering new maps. Respondents in this case challenged the new Texas map, contending that the legislature's motive was predominantly racial. Well, it was. A divided 3-judge district court agreed and enjoined the use of the new map in 2026 elections. Well, it was a 3-judge panel. It was divided, but 2 of the judges obviously ruled in favor of the plaintiffs, denying Texas its request to use the map in the 2026 midterm. And one of those 2 was a Trump-appointed judge. So I just wanted to point that out. With the 2026 campaign underway, the state of Texas and several of its officials applied to this court for a stay. Based on our preliminary evaluation of the case, Texas satisfies the traditional criteria for interim relief. So they're saying that when they looked at it, Texas satisfies what is needed for the stay. C, Indiana State Police Pension Trust versus Chrysler LLC. Texas is likely to succeed on the merits of its claim that the district court committed at least 2 serious errors. Now, before I go on, I want to remind you as well that this very same court is going to be deciding, and maybe has already decided, if Section 2 of the Voting Rights Act should be invalidated, because they would say it violates, or the way it was used, violates the Equal Protection Clause. And I've talked over and over about how ironic and dubious that is, because they're using one civil rights law against another one to achieve their purpose. And this is something that gutting Section 2 of the Voting Rights Act is something that Clarence Thomas himself has pushed for 3 decades. So if it comes back invalidated, if the court in fact invalidates it, then give all the thanks to Clarence Thomas. All right. Now, I'm not going to go very much further. I just wanted you to see that they used what I would consider technicalities here. Texas is likely to succeed on the merits of its claim that the district court committed at least two serious errors. First, the district court failed to honor the presumption of legislative good faith by construing ambiguous, direct, and circumstantial evidence against the legislature. So they're saying that the two judges on the three-judge panel committed error by not giving the Texas legislature the benefit of the doubt. Well, why would they? When the facts of the case shows, just shows outright that race was at the center of what the Texas legislature did when they redrew the maps, because it disproportionately impacts minority voters and representatives. All right. For example, Representative Mark Vesey, who is an African-American U.S. representative and could have some impact on even Representative Jasmine Crockett. All right. So the impact of the new voting map impacts minorities, racial minorities. So what else were those two judges to think? What else? So giving the legislature the benefit of the doubt would have gone against the very facts of the case. So you know what? We don't have to look any further at the case. What we will do is go to what can be done about this very biased Supreme Court. All right. So I want to just suggest some things that we can do to help the Democrats help bring in this court. All right. So we know that we got midterms coming up at the end of next year, 2026, in November, less than a year from now. And it's going to be a hotly contested midterm. You can count on that. But currently, here's the state of things. And I'm focused on the Senate, all right, because it is the Senate that has the responsibility of advising and consenting to Trump's judicial appointments. All right. And currently, the GOP does not have enough senators to get Trump's judicial appointments passed unless they finagle with the filibuster rule. Because the filibuster rule requires at least 60 senators to get something done, because the other side could filibuster whatever the Senate is trying to do. And to overcome that filibuster, there needs to be 60 senators, and currently the GOP only has 53. Democrats have 47. So big races are coming up. Not as many as we would like, but big races are coming up. All right. So, for example, these senators are up for grabs, their seats. You got John Ossoff of Georgia. He's vulnerable. He's a Democrat. So obviously we need to help him keep his seat. Gary Peters, Democrat of Michigan, he's retiring. And we need to help him, or help the next person who takes that seat be a Democrat. And then Jean Shahan, of New Hampshire, she's a Democrat and she's not running. So again, we need to make sure these three seats remain Democratic seats. All right, there are three Republican seats. Tom Tillis of North Carolina. All right, he's a Republican. He's not running. Okay, so that seat is up for grab. Those of you who are listening to me from the great state of North Kakalaki, and I use that term because I'm originally from North Carolina, and all my North Carolinian brothers and sisters know exactly what I mean when I say North Kakalaki. So we need to keep these seats so that Trump is not able to make additional appointments. Then Susan Collins of Maine and Joni Ernst of Iowa, another Republican, and she's not running. So Democrats need to do everything they can possibly, legally, to try to win these 3 Republican seats while holding on to these 3 Democratic Senate seats. So that just bottoms out, that just comes out to voting. And if the ideal thing happened, then it could make it 50-50. And of course, we know J.D. Vance could break ties and they still could get certain things done, but there's always that filibuster. There's always the potential of the filibuster. So if it ends up being 50-50, then instead of needing 7 senators to overcome a filibuster, the GOP would need 10. And then we could put a stop to Trump's agenda of appointing more far-right justices and judges. And I bring that up because there are 2 justices on SCOTUS who are up in age. Clarence Thomas and Sam Alito. They may try to retire and so that Trump can replace them with another far-right conservative justice. And we do know that sometimes people pass unexpectedly, like Antonin Scalia a few years ago. I mean, he passed unexpectedly, right? And his seat was, I think it was Amy Coney Barrett who took his seat. I think. Don't quote me on that. I'm not sure about that. But the point is, people can pass unexpectedly. So 3 Democrats are running or retiring, or vulnerable, retiring or not running, and 3 Republicans are not running. And we need to hold on to those 3 Democratic seats and pick up the 3 Republican seats. I mean, that's essentially all we can do at this point. But it's really important that we do it. It is very, 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 very important that we do it. Now, the other thing that we also should work toward is increasing the number of justices on SCOTUS. We cannot continue to have those 6 conservatives on the court rubber stamping everything that Trump and MAGA does. So it's the reason why we got to show up big in 2026. I mean, big. So that in 2028, we can actually change the size of SCOTUS. Now, let me read a little bit to you to show you how that would work. Congress.gov, changes to the size of the Supreme Court. In living memory, the Supreme Court has always had 9 members. All right? As far back as anybody can remember. However, the Constitution does not mandate a 9-justice court. All right? That is not written in stone. That is not written in the Constitution, that you got to have only 9. It's been different numbers over the years. 9 is not magical or divine. We're not talking about the divine 9. Rather, the size of the court changed multiple times in the early history of the Republic, and some recent proposals advocate further changes. Now, watch this. Article 3, Section 1 of the Constitution provides, the judicial power of the United States shall be vested in one Supreme Court. Now, that's a very definite number. There can only be one Supreme Court, constitutionally. And in such inferior courts as the Congress may from time to time ordain and establish. So we see that Congress is mentioned in Section 1 here in terms of having some authority to make changes to Article 3 courts. Although the Constitution provides that there shall be one Supreme Court, it does not specify that court's size or composition. In the absence of controlling constitutional text, that means that since it is not expressly written, Congress determines the size of the court through legislation. So again, because there is not a divine 9, a mandated 9, a constitutional 9, that means the number can be various numbers, and Congress is the one who decides what that number should be through enacting legislation. While Article 1 gives Congress the power to constitute tribunals inferior to the Supreme Court, the Constitution does not expressly grant Congress the authority to set or modify the size of the Supreme Court. Instead, Congress is understood to possess that power by virtue of the Necessary and Proper Clause, which allows Congress to legislate as needed to support the exercise of its enumerated powers and all other powers vested by the Constitution in the government of the United States, including those of the judicial branch. So we see that Congress makes that decision, although it's not expressly in the Constitution. It is still proper for Congress to make that decision. All right? All right, so let's go back over there and read a little more about Congress's authority to change the court. It would give the president who nominated the new justices significant power to shape the court in a way that aligns with the policy preferences of the president and the political party that controls the Senate. That's why I focused on the Senate first before talking about changing the size of the court. Thus, both historically and recently proposed legislation related to the size of the Supreme Court has prompted debate about the role of the judiciary and the means by which political actors may influence the Supreme Court's approach to interpreting the law. History and practice on the size of the court. As a legal matter, Congress possesses substantial authority to change the size of the Supreme Court, we just read that, through legislation that would eliminate an occupied seat on the court, might violate the constitutional requirement that justices hold their offices during good behavior. Historical practice generally reflects that understanding. All right, so we're not going to keep reading. The point here is that Congress has the authority pursuant to the Constitution to increase the size of SCOTUS. And I think we're there. The 3 justices that Trump appointed are relatively young people and will likely be on the court for another 20, 30 years. And we see how far right they are. So civil rights, voting rights, all of that are in constant jeopardy so long as the court has 6 far right justices. And the only legitimate fix is increasing the size of the court. The justices can be impeached, right? But they've not done anything that's impeachable. Now, some folks could try to make the argument that Thomas has committed impeachable offenses by all the money that reportedly he has gotten over the years, but I doubt that it would stick. All right? And even trying to impeach one of them, you would have to do so through the Senate. You would impeach in the House, but the Senate would have to prosecute and find the impeached person guilty. It's not going to happen under the current Senate, which again goes back to why it is so important to vote in November 2026. And I'm going to harp on it. I'm going to harp on it. I'm going to harp on it. I'm going to continue to push, pressure, and prod, especially our people, not to make the mistakes that many of our people made in 2016 and 2020, in 2024, by either not voting or voting for Trump. That's why we're in this mess. It's a big reason why. It's not the only, but it's a big reason why. If African Americans had voted for, in 2016, Hillary Clinton, or in 2024, Vice President Kamala Harris, we would not be having this issue. These issues of trying to fight against them rolling back what we need as a people to progress and to protect that progress. So get geared up, get fired up, everybody, about voting in less than a year. It is extremely important. So make sure your paperwork is right, make sure you're registered, make sure you haven't been purged, make sure everything is good. Start now, don't wait until October to start checking into it. Check now, check throughout the year. Start talking to your friends, your family, your co-workers, neighbors, church folks, fraternity, brothers, sorority, sisters, everybody about the need to vote in 2026. Because keep in mind, the blunt of Project 2025's policies are targeted toward us. They're anti-Black and anti-civil rights. So it's not too early to start making sure you're registered and ready to vote in 10 more of the people that you know. All right. Yes, SCOTUS is biased for Trump. The Democrats got to fix this, but we got to put them in a position to fix this. I am Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And as always, stay woke.